I've been taking my time. Taking all of your time, taking all of your time. I've been taking my time, I've been taking my time. Taking all of your time, taking all of your time. We've been talking about it for a while. Before we take a chance and do it, before we looking back as foolish. We've been talking about it for a while. Before we take a chance and do it, before we looking back as foolish. We got me floating, and I can take it. We got me floating, and I can't take it. We got me floating, and I can take it. We got me floating, and I can't take it. I've been taking my time, I've been taking my time. Taking all of your time, taking all of your time. I've been taking my time, I've been taking my time. Taking all of your time, taking all of your time. We got me floating, and I can take it. We got me floating, and I can't take it. We got me floating, and I can take it. We got me floating, and I can't take it. I've been taking my time, I've been taking my time. Taking all of your time, taking all of your time. I've been taking my time, I've been taking my time. Taking all of your time, taking all of your time.
Hey, my trendies, trendsetters, and my trendy tribe. How are y'all doing? Mic check, 1 2 1 2. Make sure you can hear me. Let me know, let me know. As that's happening, anybody that might be new to my channel, I do greet for a little bit. I will pin in the comments when I actually get on topic. So you don't have to stick through the greetings and the intro. All right. Can y'all hear me? Okay, you can hear me. Okay. LaShawn, welcome to the Trendy Tribe. LaShawn, I see you. Where you at?
Oh, bring it in. Starting from the bottom, now we're here.
Yeah. Hey. All right. I might as well also let me pop the trunk for Rick He that left me a cash out during the last live and I didn't see it. So Rick He, this is the trunk popping for you.
All right, we going. What a money reside, what a money reside, what a money reside, what a money reside.
All right. Again, if you're just coming in, I'll pin in the comments when I get to the actual topic. Hey, Braylon Lee, how you doing? Yes, a lot's going on. Hey, sweet sis, 41 Fit, part of the Mod Squad, also a content creator, and Braylon is a content creator as well. Hey, sis, too blessed for you. Veronica Monroe, Mama Bees. Hey, just listening. Live, Laugh, Love is a content creator, and she's in the Mod Squad. Hey, May, June, July, Josie Bradley. Uppity Unicorn, my Unisis is here. Oh, hey, Trendy Corn. I love it. I'm a Trendy Corn. I love it. Hey, feels good being me. Joy S. Pick. Hey, welcome again, LaShawn. Chanel H. Hey, y'all. Hey. Hey, Professor Purple Queen. Kim Jones. Good afternoon. Hey, Rosie. Let's see. She said, I know I hear it every time. This song is good. Mama Bees is saying, okay, she worked out again. Yes, I know you're Claudia. I thought you didn't want me to say anymore, but you're talking to 41 Fit. Got you. Yes. Hey, Bama girl. Let's see. Hey, Sylvia P. Okay. Pumpkin, I see you. And let me see. Kim Jones said, "Hey Trent, I was trying to send you my pic in my cancer t-shirt on Instagram, but I couldn't get your name to highlight." I don't know. I'd have to see it from your end to know. I don't know why it's not doing it. I'm not sure. If you just search my name in Instagram, and then it'll say, when you go to my profile, you can hit the message button and just message me, and then add the picture through the message like that, through the DM. I don't, because the other way, I don't know the other way. All right, let me get to it. I'm taking this down. Shout out to the people that was ordering today. I saw y'all, Pisces, Leos. I think a Virgo ordered recently. Let me see. I'm bringing up my screen, y'all, just so you know. Okay. No, I only had time to redact a little bit. I did not have time to highlight. And y'all saw the title. Kevin Hart is suing Tasha K for alleged extortion. Let me bring it up here. All right. Let me see. Gotcha. All right. So it says this is So it is Kevin Hart, an individual, K Hart Enterprises Incorporated, a California corporation, are the plaintiffs versus Miesha Shakes, an individual, which I believe that's Kevin Hart's former assistant, and Latasha Kebe, Kebe Studios, and Does 1 through 20 inclusive. So, okay. The complaint is for civil extortion, breach of contract, intentional interference with contractual relations, invasion of privacy. It says public disclosure of private facts, and defamation. So that's what it's for. Okay. I'm going down because I usually just establish jurisdiction at first. So, okay, so we're going to go here first. So plaintiffs are Plaintiffs are informed and believe, and based thereon allege, that at all times mentioned herein, defendant Shakes was and is an individual residing and doing business in Los Angeles County, California, beginning in or around August 8th, 2017, and continuing through October 22nd, 2020. Shakes was employed with Heartbeat Productions, LLC, a KHE predecessor entity, in various capacities, most recently as Hart's personal assistant. Plaintiffs are informed and believe, and based thereon allege, that at all times mentioned herein, defendant Latasha Kebe was and is an individual residing in the states of Georgia and Florida who regularly transacts business in the state of California and county of Los Angeles, including in connection with the matters at issue herein. Plaintiffs are informed and believed, and based thereon allege, that at all times mentioned herein, defendant Kebe Studios was and is a Georgia limited liability company. So they're establishing jurisdiction, I believe. So I'm going to go down just a little bit more. Okay, plaintiffs are informed and believed, and based thereon alleged, that Kebe, through Kebe Studios, operates a website, TashaKLive.com, and is active on various social media platforms, including but not limited to Instagram and YouTube, wherein Kebe specializes in posting salacious and unverified news, i.e. gossip about celebrities. Kebe has an established history of posting defamatory and otherwise improper content regarding celebrities. For instance, most recently, she was found liable for damages exceeding $3 million in a defamation lawsuit by the musician Cardi B. Plaintiffs are unaware of the true names or capacities of the defendants sued herein under the fictitious names Does 1 through 20 inclusive, and sue said fictitiously named defendants in accordance with California law. Plaintiffs are informed and believe, and based thereon allege, that at all times herein mentioned Does 1 through 20 are and were individuals, corporations, associations, or otherwise. Plaintiffs will amend this complaint to allege their true names and capacities when they become known to plaintiffs. Shakes, Kebe, Kebe Studios, and Does 1 through 20 are hereinafter referred to collectively as defendants. Plaintiffs are informed and believes and based thereon allege that at all times mentioned herein, defendants, including those 1 through 20, were the agents, employees, representatives, fiduciaries, insurers, and or co-conspirators of each other, and that defendants were acting within the course and scope of such relationships and are responsible for the acts alleged herein and as proximate cause for plaintiffs' damages. Okay, let's see. Facts common to all causes of action. It says during the course of her employment with Hart and Heartbeat, Shakes served as Hart's personal assistant. In said capacity, Shakes was privy to certain confidential business and personal information regarding Hart, his family, friends, and associates, various Heartbeat personnel, and employees at other Hart-affiliated companies. As a result, Shakes appeared to be in a position to disseminate or confirm allegations about those persons and entities, regardless of their truth or falsity. All right. Let's see here. Okay, Josie said, I've seen this interview, and this girl said a lot. She said Kevin has kids he doesn't claim. Ooh, child. Okay. Upon Shakes entering her employment relationship with Heartbeat, Shakes and Heartbeat entered into that certain confidentiality agreement dated August 8th, 2017. A true and correct copy of the confidentiality agreement is attached hereto as Exhibit A, and we most likely will look at the exhibits presented. The confidentiality agreement defined confidential information to include the following: matters concerning the business operations, business ideas, know-how, techniques, methodologies, and business relationships of any of the protected parties, with protected parties defined to include Heartbeat's owner, its officers, directors, shareholders, clients, family, friends, associates, and contractees, including but not limited to affiliated entities of owner. The confidentiality agreement further provided that Shakes expressly agrees that recipients shall not directly or indirectly, verbally or otherwise, publish, disseminate, disclose, or cause to be published, disseminated, or disclosed any confidential information to any person, firm, or entity whatsoever. On or around October 22nd, 2020, Shakes, on the one hand, and Hart, on behalf of himself, Heartbeat, and all other Hart-affiliated companies, on the other hand, entered into that certain mutual release and non-disclosure agreement dated October 22nd, 2020. A true and correct copy of the NDA is attached hereto as Exhibit B. The NDA called for Hart to pay Shakes $30,000 per year for a period of 3 years, along with other consideration. Ooh, that is low. And they living in California too. And she was an assistant. $30,000 a year is low. The NDA defines as confidential information the following: private and confidential information which is not generally known to the public or readily ascertainable by proper means by others and is subject to reasonable efforts to maintain its secrecy pertaining to any of the following protected parties. I'm going to skip them naming all the protected parties again. The NDA further provides that Shakes shall not directly or indirectly disclose, exploit, or disseminate confidential information to any person or entity whatsoever, including but not limited to friends, family members, journalists, tabloids, television or radio programs, websites, or internet social media, example, Facebook, Twitter, Instagram, TikTok, Snapchat, all collectively third parties, or threaten to do so. Shakes therefore had the duty to preserve the confidential information both as defined in the confidentiality agreement and in the NDA as confidential. The NDA included an attorney's fee clause providing as follows: in any proceeding arising out of or related to this agreement or its enforcement, the prevailing party shall be entitled to recover all of his, her, its reasonable attorney's fees, costs, and expenses incurred. In or around November 2023, Kibi conducted and recorded an interview, they're going to call it the interview, with Shakes, wherein Shakes made various statements regarding Hart, his family, and Heartbeat personnel and or employees of other Hart-affiliated entities. Notwithstanding the truth or falsity of any such statements, Shakes would only have had knowledge regarding such subjects as a result of her employment with Hart and Heartbeat. Oh, okay, thank you. Thank you. I saw those emojis. Thank you. Such information necessarily would have constituted confidential information as defined by the NDA, such as information regarding alleged personal relationships affecting the employment status of personnel at Hart-affiliated companies and subjects such as Hart's interactions with his family members. The interview also included false and defamatory statements regarding Hart and certain legal disputes in which he had been involved. During the interview, Kibi asked Shakes whether she was subject to any NDAs which would have prohibited her from disclosing the type of information that was the subject of the interview. Shakes acknowledged that she and plaintiffs were in fact party to the NDA, but claimed that the agreement had unspecified loopholes that she apparently contended would enable her to escape the consequences of her brazenly violating her promises to plaintiffs and the NDA and confidentiality agreement's terms. In or around November 2023, an unidentified individual telephoned a Hart representative stating that the individual was affiliated with Kibi, that Kibi had conducted the interview with Shakes, and that the interview included information or allegations that the Kibi representative claimed would be damaging to Hart's reputation. The individual stated that Kibi would publish the interview unless Hart paid a ransom of $250,000. On or around November 17th, 2023, Kibi posted a teaser for the interview on YouTube, wherein she, along with Shakes, touted the supposedly salacious and damaging nature of the interview. The teaser video clearly was intended as a threat to Hart that the more detailed interview would be published if the ransom was not paid. The teaser included a statement from Kibi at the 2-minute 6-second mark of the video, specifically warning that when you don't pay, we have to get money by any means necessary. Ooh. Hart and his representatives contacted the police and did not pay the ransom that Kibi was demanding. On or around November 22nd, 2023, Hart's attorney, Dante Mills, wrote to Kibi demanding that she cease and desist all of her legally impermissible actions towards Hart and that she refrain from publishing the interview. A true and correct copy of that cease and desist letter is attached hereto as Exhibit C. In that cease and desist communication, Mr. Mills specifically advised Kibi that Hart had contacted law enforcement about her threats. The cease and desist letter also advised Kibi that Hart and Shakes were parties to the NDA, that Shakes' participation in the interview was a violation of the NDA, and that Kibi's publication of the interview would constitute intentional interference with contractual relations in addition to the various other criminal and tortious conduct that Kibi had engaged in up to that point. On December 22nd, 2022, Kibi advised Hart's representatives that she would in fact be publishing the interview. That evening at approximately 6 p.m. Pacific Standard Time, Kibi published the interview on her website, TashaKLive.com, especially at the link, and they list the link, charging viewers a $12 per month subscription fee in order to access and view the interview. Okay, I'm going to pause for a second. And hey, y'all that have come in, yep, that's one of the complaints. Extortion is definitely on the list. Extortion, defamation, there's some other things on there. For those of y'all that are coming in, let's see, I'm on page 7. Just so you know, the complaint is for civil extortion, breach of contract, intentional interference with contractual relations, invasion of privacy, public disclosure of private facts, and defamation. So five counts or complaints. I don't know. It's one complaint with 5 pieces. Let me get back to my where we were going to. Let's see. Okay, first cause of action. Plaintiffs, the first cause of action is civil extortion against all defendants. Plaintiffs hereby incorporate by reference paragraphs 1 through 28 inclusive, as if fully set forth herein. All right. California courts recognize a private right of action for civil extortion under California Penal Code sections 518 and 519. The act of contacting an individual and threatening to make public statements about them in order to induce payment of money is extortion pursuant to California Penal Code sections 518 and 519. The statement by Kibi's representative that the interview would be published if Hart did not pay constitutes extortion as defined in California Penal Code sections 518 and 519. As a direct and proximate result of the acts described above, plaintiffs have been damaged in an amount to be proven at trial. Defendants' extortionate threats were done with oppression, fraud, and malice with the intention of depriving plaintiff Hart of his personal liberty, property, or legal rights and otherwise causing injury, and such actions were despicable, conduct that subjected plaintiffs to unjust hardship and conscious disregard of plaintiffs' rights, such that plaintiffs are entitled to recover punitive and exemplary damages in addition to all actual and statutory damages to which plaintiffs are entitled in order to set an example and deter such conduct. Second cause of action, breach of contract against Shakes. Shakes was his former assistant. So basically, it's all true. Allegedly, it's the fact that the lady signed an NDA and the CC publicized it. Allegedly, I don't know. I don't know. I'll try to get my opinions at the end. I have a couple of opinions. Plaintiffs hereby incorporate by reference paragraphs 1 through 34 inclusive. Plaintiffs and Shakes are parties to the NDA, which is supported by valid consideration, including but not limited to Hart's payment of $90,000 to Shakes. You know what, Love Key? I'm going to say it now. There is a paragraph in here where they said that because of her proximity to them and what she would have been privy to, that anything she would say on the interview would more likely be believed because she was with them. That's how they put it. That they're not claiming it or any of it may be true, but there could be stuff mixed in there that may not be true, but you're more likely to probably believe it because she was up under them. So that's what the paragraph has said. Okay. Plaintiffs have performed all of the terms, conditions, covenants, and promises required to be performed by them under the NDA, except those terms, conditions, covenants, and promises, if any, which Shakes prevented plaintiffs from performing. Shakes has breached the NDA by disclosing information and or making allegations that would necessarily entail disclosure of information defined as confidential information under the NDA, including statements regarding personnel and employment matters at Heartbeat and or other Hart-affiliated companies, and statements regarding Hart's interactions with his family members. As a direct and proximate result of Shakes' material breaches of the NDA, plaintiffs have suffered damages, including without limitation, in the principal sum of $90,000 that Hart paid as consideration under the NDA, in addition to further damages in an amount according to proof at trial. Third cause of action, intentional interference with contractual relations against Kibi. Plaintiffs hereby incorporate by reference paragraphs 1 through 39. If you're just coming in, Kibi is Tasha K. At the time of the interview, Kibi was aware that plaintiffs and Shakes were parties to the NDA, with Kibi specifically asking about and Shakes specifically confirming that she and plaintiffs were parties to said agreement. After the interview, Kibi was further advised that plaintiffs and Shakes were parties to the NDA, that the subject matter of the interview necessarily constituted confidential information as defined by the NDA, and that publication of the interview would constitute interference with the NDA. Despite being fully aware of plaintiffs' contractual relationship with Shakes under the NDA, Kibi published the interview after undertaking the independently wrongful conduct of making the extortionate threats described herein. As a direct proximate result of Kibi's conduct, plaintiffs have suffered damages in an amount according to proof, including without limitation not less than $90,000 Hart paid as consideration under the NDA, in addition to damages in further amounts according to proof at trial. The actions of Kibi in intentionally interfering with plaintiffs and Shakes' contractual relationship under the NDA were done with oppression, fraud, and malice, with the intention of depriving plaintiffs of their personal liberty, property, or legal rights, and otherwise causing injury. And such actions were despicable conduct that subjected plaintiffs to unjust hardship in conscious disregard of plaintiffs' rights, such that plaintiffs are entitled to recover punitive and exemplary damages in addition to all actual and statutory damages to which plaintiffs are entitled in order to set an example and deter such conduct. Fourth cause of action, hey Golden's Candy, invasion of privacy, public disclosure of private facts against all defendants. Plaintiffs hereby incorporate, by reference, paragraphs 1 through 45. Then it says, in the interview, defendants disclosed purported private facts regarding Hart, his family members, Heartbeat employees, and or personnel at other Hart-affiliated companies. The interview was published on defendant Kibi's website and thereby disclosed publicly. Some of the matters Shakes purported to disclose suggested private facts, including but not limited to statements regarding personal relationships affecting the employment status of personnel at Hart-affiliated companies and interactions among Hart and his family members. The publication of such facts would be offensive and objectionable to the reasonable person. The purported private facts published during the interview are not of legitimate public concern. Defendants' actions in publishing private facts regarding plaintiffs were done with oppression, fraud, and malice with the intention of depriving plaintiffs of their personal liberty, property, and legal rights, and otherwise causing injury, and such actions were despicable conduct that subjected plaintiffs to unjust hardship and conscious disregard of plaintiffs' rights, such that plaintiffs are entitled to recover punitive and exemplary damages. Fifth cause of action, defamation against defendant Shakes. During the interview, Shakes made a number of statements regarding plaintiff Kevin Hart. Those statements were published on Kiwi's website. Shakes made statements during the interview that were false, including that Hart recorded a video of a sexual encounter and that he faced criminal charges regarding that supposed incident. Such statements were defamatory and were not privileged. Such statements had a natural tendency to injure Hart. Shakes' actions in publishing defamatory statements regarding Hart were done with oppression, fraud, and malice with the intention of depriving Hart of his personal liberty, property, legal rights, everything that they said in the other ones. Prayer is, therefore, plaintiffs pray for judgment against defendants as follows. They want general, for the first cause of action, extortion, they want general damages according to proof in excess of the jurisdictional minimum for this court. They want compensatory damages according to proof and punitive damages as allowed by law. As to the second cause of action, breach of contract, he wants compensatory damages according to proof, but in an amount not less than $90,000, attorney's fees and costs of suit herein. Third cause of action, they want damages according to proof, compensatory damages according to proof, but in an amount not less than $90,000, punitive damages as allowed by law. Fourth cause of action, they want compensatory damages according to proof in excess of the jurisdictional minimum for this court and for punitive damages as allowed by law. As to the fifth cause of action, defamation, they want compensatory damages according to proof in excess of the jurisdictional minimum for the court and punitive damages as allowed by law. And on all causes of action, they want a prejudgment interest as allowed by law, costs of suit herein incurred, and any or such other and further relief as the court may deem proper. So we're about to look at their confidentiality agreement. Okay, so it's showing August 8th, 2017 was the effective date, and it was made between Heartbeat Productions and Miesha Shakes. And let's see here. Okay. I'm taking a breath. Let me drink some water. Hold on, y'all. 1 second. All right. So I might skip over some of these paragraphs, but the confidential part really matters. So we'll go over that. It says, in the course of recipient's engagement by one or more of the entities constituting owner proposes to disclose certain of its confidential information to recipient. The term confidential information shall be defined to include, but not be limited to, any and all of the following information and items relating to or concerning owner, its officers, directors, shareholders, clients, family, friends, associates, and contractees, including but not limited to affiliated entities of owner Kevin Hart or Leland Pookie Wigington, or any other companies with which owner of Mr. Wigington is affiliated, sometimes collectively referred to as the protected parties. Okay, so number one, matters concerning the business operations, business ideas, know-how, techniques, methodologies, and business relationships of any of the protected parties. 2, data, materials, products, technology, computer programs, specifications, manuals, business plans, software, marketing plans, financial information, letters, memoranda, contracts, or other documents or writings pertaining in any way to any of the protected parties. 3, other confidential and or proprietary information belonging to or licensed to the protected parties, including, but is not limited to, trade secrets, inventions, patents, and copyrighted materials. And 4, any other information disclosed or submitted orally, in writing, or by any other medium to recipient by one or more of the protected parties. Confidential information disclosed orally may be identified as such, but the failure to provide such disclosure shall not mean that the information is not confidential information. Nothing herein shall require the protected parties to disclose any of its confidential information to recipient. Confidential information may be made confidential by law or by the protected party's policies and may be in any form, including but not limited to observations, data, written materials, records, documents, drawings, photographs, computer programs, software inventions, discoveries, improvements, developments, tools, machines, apparatus, appliances, designs, works of authorship, logos, systems, promotional ideas, customer lists, customer needs, practices, pricing information, processes, tests, concepts, formulas, methods, market information, techniques, trade secrets, product and or research related to the actual or anticipated research developments, products, organizations, marketing, advertising, and or business or finances of the protected parties. The recipient also understands that access to all confidential information is granted on a need-to-know basis. So the recipient's obligations, let's see, is this one? It was the assistant who shared the alleged opinion. So a case between Tasha K is a bit of a reach. Oh, in this one, it was the assistant who shared the alleged opinion. Well, the part where Tasha K for sure is being included is because he's alleging that Tasha K extorted him for money so she wouldn't do the interview. That's one of the main reasons he has Tasha K's name in it. They're alleging that she was like, if you don't give me $250,000, I'm going to publish this interview. That was one of the, I think the main reasons Tasha K's name is in it. And it's alleged. It has not been proven at this time that I know of. The courts will do it out. I'm going to read the document. They left no crumbs. Right. Okay. Continuing to read this. Recipient expressly agrees that recipient shall not directly or indirectly, verbally or otherwise, publish, disseminate, disclose, or cause to be published, disseminated, or disclosed any confidential information to any person, firm, or entity whatsoever, including but not limited to friends, relatives, co-workers, newspapers, publications, television stations, radio stations, computerized websites, publishers, or any other enterprise involved in the print or electronic media, including individuals working directly or indirectly for or on behalf of any said entities. Herein, they'll be known as third parties. Can belong to, so that also is an issue if they share the NDA with her. Oof. Okay, recipient agrees that the confidential information is to be considered confidential and proprietary to the protected parties, and recipient shall hold the same in confidence, shall not use the confidential information other than for the purposes of its business with the protected parties, and shall disclose it only to its officers, directors, or employees with a specific need to know. Recipient will not disclose, publish, or otherwise reveal any of the confidential information received from the protected parties to third parties, except with the specific prior written authorization of one or more of the protected parties. Confidential information furnished in tangible form shall not be duplicated by recipient except for purposes of this agreement. Let's see. Any documents or other media developed by the recipient containing confidential information must be destroyed by recipient, and recipient shall provide a written certificate to owner regarding destruction within 10 days thereafter. Confidential information may not be removed from the premises without written permission or electronically submitted outside of the owner, including through social media. Removal without written authorization or use in social media is grounds for immediate termination without notice. Without limiting the foregoing, recipient shall respect and maintain the confidentiality of all discussions, deliberations, and any other information generated in connection with owner, and recipient will not post or share information or photos about discussions or business-related matters or activities or online in any form, including but not limited to email, websites, message boards, blogs, or social networking websites. Recipient will not share any client personal information, content, or graphics on any social media. Recipient shall not utilize or deal directly or indirectly, interfere with directly or indirectly, circumvent or attempt to circumvent, avoid, bypass, or obviate owner or owner's interests directly or indirectly in whole or in part through agents, intermediaries, or otherwise with respect to owners, customers, clients, suppliers, distributors, manufacturers, consultants, brokers, employees, for any reason or purpose whatsoever, including without limitation to change, increase, decrease, or avoid directly or indirectly payment of established or to be established fees, commissions, or continuance of pre-established relationships, or intervene in non-contracted relationships with manufacturers or suppliers, or initiate buy-sell relationships or transactional relationships that bypass owner with any corporation, producer, owner, supplier, buyer, or individual used, revealed, or introduced by owner to obligated party, or vice versa, in connection with any ongoing or future transaction. Okay. I'm looking at the term. That is okay. Yeah. So this is the term. The obligations of recipient herein shall commence on the effective date, and recipient's non-disclosure and other obligations hereunder shall continue in full force and effect indefinitely. Recipient's obligation not to disclose shall not be affected by bankruptcy, receivership, assignment, attachment, or seizure procedures, whether initiated by or against recipient, nor by the rejection of any agreement between owner and recipient, by a trustee of recipient in bankruptcy, or by the recipient as a debtor in possession, or the equivalent of any of the foregoing under local law. Okay. I'm reading ahead to see. Sorry, y'all. By signing this agreement, the recipient affirms that recipient will protect all confidential information while engaged by the owner, and after the recipient has completed all services and obligations for the owner. The recipient affirms that all confidential information remains the property of the owner and may not be removed or retained when the recipient has completed services and obligations, except as permitted in writing by the owner's policies. Recipient acknowledges that the protected parties have substantial and valuable property rights and other proprietary interests in the possession, ownership, and use of the confidential information. In the event recipient acquires, creates, or obtains any materials by virtue of recipient's access to confidential information, then recipient agrees and acknowledges that said material shall also be considered confidential information that shall be owned solely by owner. Nothing contained herein shall be construed as granting or conferring any rights by license or otherwise in any confidential information. It is understood and agreed that neither party solicits any change in the organization, business practice, service, or products of the other party, and that the disclosure of confidential information shall not be construed as evidencing any intent by a party to purchase any products or services of the other party, nor as an encouragement to expend funds in development or research efforts. Confidential information may pertain to prospective or unannounced products. Recipient agrees not to use any confidential information as a basis upon which to develop or have a third party develop a competing or similar product. It says no publicity. Recipient agrees not to disclose its participation in this undertaking, the existence or terms and conditions of the agreement, or the fact that discussions are being held with the owner. Excuse me. Yes, bless you, like a Leah 9-page letter. Okay. Let's see. I'm going down a little bit. Okay. Recipient may not assign this agreement or any interest herein without owner's express prior written consent. 1 second. I might need to read this. Let's see. The agreement shall be governed and construed in accordance with the laws of the United States and the state of California, and recipient consents to the exclusive jurisdiction of the state courts and U.S. federal courts located there for any dispute arising out of this agreement. Recipient agrees that in the event of any breach or threatened breach by the recipient, owner may obtain, in addition to any other legal remedies which may be available, such equitable relief as may be necessary to protect the owner against any such breach or threatened breach. Severability. If any term of this agreement is held by a court of competent jurisdiction to be invalid or unenforceable, then this agreement, including all of the remaining terms, will remain in full force and effect as if such invalid or unenforceable term had never been included. That's important. So they're saying that if there's something in there that doesn't really apply to California law or whatever jurisdiction, then that particular term, okay, it's out. But that does not make the whole agreement null and void, which is a very important paragraph. Okay, notices. Any notice required by this agreement or given in connection with it shall be in writing and shall be given to the appropriate party by personal delivery or by certified mail. Okay. Either party's failure to insist in any one or more instances upon strict performance by the other party of any of the terms of this agreement shall not be construed as a waiver of any continuing or subsequent failure to perform or delay in performance of any term hereof. Final agreement. This agreement terminates and supersedes all prior understandings or agreements on the subject matter hereof. This agreement may be modified only by a further writing that is duly executed by both parties. Okay, so that I mean, woof, okay. I'm not gonna read the full NDA. I'm trying to pick out the thing because I feel like that first agreement really covered a lot. Let's see here. I was looking to see if this mentioned the $90,000 in this one too, but again, she was paid $30,000 over a course of 36 months. So $30,000 per year. It's defining protected parties, trade secrets. Okay, paragraph 1.2. Agreement not to disclose or use confidential information. Okay, it repeats the same as the other one, in my opinion. Enough to where I won't read you, I won't make you go through that whole paragraph again. No use of name or likeness. Shakes shall not directly or indirectly exploit the names, likenesses, and or identities of the protected parties to promote, advertise, endorse, or market any services or products of any kind or nature without Hart's advance written consent. Okay, it's about the recordings again. Shakes may permitted disclosures responding to subpoenas, etc. Shakes may disclose confidential information in confidence and pursuant to legal privilege to her attorneys as required for the rendition of their professional services or as is otherwise required by law. If Shakes is compelled to disclose confidential information pursuant to valid legal process, she shall first provide Hart with reasonable advance written notice pursuant to this agreement's notice provision. Shakes shall not volunteer to disclose confidential information. Remedies for breach. If Shakes breaches this agreement or threatens to do so, she shall be liable to Hart for all resulting damages, including but not limited to all of the following, all of which shall be cumulative to be sought pursuant to this agreement's mandatory arbitration provisions. So liquidated damages, it says Shakes will be obligated to pay Hart the sum of $50,000 as a reasonable and fair amount of liquidated damages to compensate Hart for loss or damage resulting from each actual or threatened breach. The parties agree that this sum bears a reasonable and proximate relationship to the actual damages Hart will suffer from each actual or threatened breach and that it is not a penalty. Alternatively, Hart shall have the right to seek actual damages according to proof instead of liquidated damages. And that's what that complaint said. He was seeking damages according to proof. That's what they said throughout each count, I think. Disgorgement of ill-gotten gains. Shakes' actual or threatened breach will obligate her to account to Hart and turn over to Hart all monies, consideration, profits, or other benefits Shakes derives from her breach without prejudice to Hart's other legal or equitable rights or remedies. Whew. Okay. Injunctive relief. Hold on, y'all. I gotta clear my throat again. What did 41 Fifth say? I see y'all laughing at her. These losses use every word in the dictionary, child. Portraying the tongue is dry like a Popeye's biscuit. No wonder they were laughing at you. Oh my gosh. Okay. Since Shakes' actual or threatened breach will cause Hart irreparable injury, which cannot be adequately compensated by money damages, Hart shall be entitled to obtain temporary, preliminary, and permanent injunctive relief to prevent Shakes' breach or further breach. The balance of potential harm to Shakes arising from injunctive relief is substantially outweighed by the substantial harm to Hart resulting from unauthorized dissemination or exploitation of confidential information. Shakes agrees that despite the arbitration provisions below, Hart is entitled to seek injunctive relief in any court of competent jurisdiction to prevent Shakes' breach of this agreement and to secure its enforcement, and that Hart seeking such injunctive relief from a judge or court shall not be deemed incompatible with or to constitute a waiver or relinquishment of any party's right or obligation to arbitrate disputes. Again, they'll be responsible for attorneys' fees and costs. They have a mandatory confidential binding arbitration of disputes. That's in bold. I won't go over that, but it looks like they have to go through arbitration is the way they titled it. Mutual release. Let's see. Except for the obligations arising from this agreement, the parties on behalf of themselves and their heirs hereby irrevocably, unconditionally, and completely release, discharge, and hold each other and each of their current and former agents, employees, reps, assigns, predecessors, successors, principals, partners, attorneys, managers, publicity reps, and insurers, including the protected parties, and each of them harmless from any and all claims, liabilities, suits, causes of action, demands, damages, debts, obligations, controversies, costs, expenses, and judgments of every kind of or character arising in law or equity under contract, tort, governmental regulation, state or federal law or statute that the parties ever had, now have, or hereafter may have against the releasees throughout the world, based upon or by reason of, in whole or in part, any act or omission to act, transaction, practice, or conduct, whether known or unknown, suspected or unsuspected, foreseen or unforeseen, arising or existing at any time before the execution of this agreement. The parties forever waive and relinquish as to the released claims the provisions, rights, and benefits, if any, of California Civil Code Section 1542, and all rights and benefits under similar law of any other jurisdiction to the fullest extent that they can be waived. Okay. Okay, I'm not going to read that one. Okay, this is the letter that was sent to Tasha K from who did at the end of this, I think it's by Kevin Hart's lawyer. I'm pretty sure I saw his name at the bottom. It's a mess. I wonder why the assistant decided to do this. Did she lose her job? If the interview's still up, you might want to catch it before it comes down, because I don't know. Okay, it says, Ms. Keeby, this office represents Kevin Hart. I am writing regarding your recent and ongoing violations of civil and criminal law, and to demand that you immediately cease and desist all such activity. You have already engaged in criminal conduct and tortious acts that would entitle Mr. Hart to monetary damages against you should he elect to commence civil litigation regarding this matter. To the extent that you do not cease and desist now, your liability for such monetary damages will increase, as will your exposure to criminal penalties. As you are no doubt aware, recently someone on Mr. Hart's team was contacted by an unknown individual who indicated that he was affiliated with you and or your blogs. This individual, working at your direction, stated that you would publish a story on social media that you contend would be damaging to Mr. Hart's reputation unless Mr. Hart pays $250,000. This, of course, constitutes extortion under Penal Code Section 518, and gives rise to both criminal and civil liability against you and anyone involved in your efforts to extort Mr. Hart. California's extortion law prohibits any attempt to obtain consideration from another through the wrongful use of force or fear. Penal Code 518, your effort to extract payment from Mr. Hart by threatening exposure of information supposedly harmful to him is a textbook example. We have thus contacted the police and will be following up with law enforcement as we deem appropriate. We understand the story to be an interview with Mr. Hart's former assistant, Miesha Shakes, that supposedly includes scandalous assertions against him. We note that Ms. Shakes has a documented history with law enforcement in matters involving other high-profile individuals. In advance of your threatened publication of the story, you posted a teaser with Ms. Shakes on YouTube, which clearly was intended as a threat, sending a message to Mr. Hart's team that the more detailed story would not be published if and only if the ransom is paid. Your statement at approximately the 2-minute 6-second mark of the teaser video that, quote, when you don't pay, we have to get money by any means necessary, end quote, is particularly damning and leaves no ambiguity that criminal extortion was your intent. In addition to liability arising from such criminal conduct, The threatened activity would constitute a violation of a non-disclosure agreement between Mr. Hart and Ms. Shakes, that certain mutual release and non-disclosure agreement dated October 22nd, 2020 between those individuals. While we do not presently know the specifics of the story or of Ms. Shakes' assertions, the subject matter of the story to which the YouTube teaser alludes would necessarily derive from information Ms. Shakes gained while in Mr. Hart's employ and thus fall squarely within the NDA's definition of confidential information. Any such disclosures from Ms. Shakes in connection with the story therefore constitute a clear violation of the NDA's terms. To the extent that you were to facilitate such a breach of the NDA by publishing the story, you would be subject to civil liability for intentional interference with contractual relations, as well as aiding and abetting Ms. Shakes' tortious conduct against Mr. Hart, in addition to direct liability resulting from your own tortious conduct. We are aware of the fact that you have an established history of posting defamatory and otherwise improper content regarding celebrities and other high-profile individuals. For instance, most recently, you were found liable for civil damages exceeding $3 million in a defamation lawsuit by the musician Cardi B. You and your accomplices' actions with respect to Mr. Hart are more of the same, in addition to being flatly criminal as set forth above. Your adjudicated history of such misconduct is further evidence of your intent in this case, leaving no doubt as to your liability here. We also are aware that you have recently filed for bankruptcy protection. You should be advised that under Bankruptcy Code Section 523, debt incurred as a result of a debtor's willful or malicious injury to a creditor, here Mr. Hart, is not subject to discharge. You will thus not be able to evade any liability for monetary damages to Mr. Hart that you incur as a result of the misconduct described herein, which would not constitute dischargeable pre-petition debt in any event. In light of the foregoing issues, we demand that you immediately cease and desist all activity and public statements relating to the story and refrain from any publication or threatened release of the story. Please have your attorneys contact me to discuss this matter in further detail. We note that the foregoing is not an exhaustive recitation of applicable facts and law relevant to this matter, and none of the above constitutes a waiver of any of Mr. Hart's rights or remedies with respect thereto. And that is the last page. It's me bedazzle. That's child right there. Child. Oh my God. Oh my gosh. Okay. We'll wait for, them to file an answer to the complaint, I guess. Here, a couple of my thoughts. It seems like she definitely shouldn't be saying anything because that thing had an indefinite time frame, but I don't know really how confidential agreements and NDAs work. I read the terms. That don't mean I know what your lawyer can work out with you when you do end up saying some certain things. Also, I saw that video. This is not about Kevin Hart as far as the infidelity part, but I saw that one video where he was fussing with one of his trainers, and he was saying he made him, he wouldn't be anything without him. It was something that was kind of cringy. Oh, he kept it in his own special or something on Netflix. That's how I saw that. And I was like, ooh, okay. But I don't know. That being said, I don't think that has it. With Tasha K, I think what might stick, if it actually happened, if they have proof and they can connect it back that one of her people actually got the thing from her or just in association with her, because if they're employed by her, that if she actually had said or they said, if you don't want us to release this story, you have to give us $250,000. That seems like the strong part of it when it involves Tasha K's name. What I don't know is, let's say nobody had ever reached out to Kevin Hart. Nobody said anything about I'm with Tasha K. None of that. What if Tasha K just ran the story? I do want to know, what will the courts decide that the former assistant could allegedly be speaking about confidential information? What responsibility legally, enforceably, will Tasha K have for that? Since she did ask her, are you under a confidentiality agreement and stuff like that? That's one of my questions. What will the court say about that? I am so curious on that one. The girl also said he set up his best friend, allegedly. Look, I ain't over there. I ain't watching it. I didn't see it. I didn't see none of that. Now, was I curious? Heck yes, I was curious. I even if I see it, I ain't gonna recap it over here right now because I don't know what the heck is going on. I need to know if what's gonna be enforced by the confidential agreement, what the courts are gonna say. Dante Mills Esquire ain't playing games with the Saints, and he not. Live, laugh, love said, let me go listen. Oh, sis, be careful. Essie said, but Tasha K made a remark about money on her YouTube channel. That's where they gathered it. Oh, no, I get that. She made a remark, and they gave the timestamp. I'm not saying that. I'm just saying that statement, to me, if they don't have the other part to connect, that she's actually, sent somebody, or they went out there to say you have to give us, because they specifically named an amount in the extortion part, $250,000. If she didn't say that in her video, I'm saying, I wonder, do they have that to connect back with her? And I'm just saying that I feel like that's the strongest part if they have it against Tasha K. Shan said, in my opinion, the court will say the info the NDA covers belongs to him, especially when Tasha K knows there's one. Ooh, okay. Hey, Mimi. y'all, I can't even be mad at you. First, little bro said, I'm listening to it before Tasha K takes it down. Well, Essie, I see you. I see what you're saying, Essie, but that comment isolated, unless she said, since you didn't give me the money, I'm doing the interview, because what they quoted her saying was that, let me find the quote, because my thing is, sometimes things have to be put together. Isolated, I don't know if that would be enough as far as the extortion. If she said, I'm finding her quote. Hold on, because I'm going to do it how they claim she said it. Where's it at? This is what she said in the quote that they're telling her cease and desist. She said, when you don't pay, we have to get money by any means necessary. That alone, I'm wondering, would that be enough? If there wasn't anything else, would that have been enough to say that's still extortion? That's what I'm wondering. We'll see when the court rules, if it goes all the way, like the other one did. I don't, Celicia, I definitely don't know. I do not know. The interview, she might say when she stopped, or I can't imagine she's still working for him, but I'm sure in the interview she probably says when her employment terms were. She demanded money in advance, and that nut said it on her own show. I see y'all. Okay, context is everything. Yes, it's everything, because when you're in court, it does get down to the nitty gritty. They don't like a lot of inference and guessing and all that stuff. So that's all I'm saying. Hopefully Tasha has new legal team. Now that, yes, talking out loud. Talking out loud as a content creator, yeah. Civil is a lot more lenient. I see this making it to court. Got you. Preponderance of the evidence, right, Shan? That's civil, right? Tasha is ending the year very badly. Oh my gosh. I wonder why. Why? And see, I went over there to watch the recap of when she interviewed side chick Sonya, Nesto's side chick, right? And I saw our content creators over there, and that lane, that's a good lane, because those things are in court. They've got, here's the supporting documents. I was like, dang, I don't know how, I hadn't been over there in like 2-3 years, and I went over there for the Nesto stuff. I'm like, dang, you should maybe, I don't know. That's on her. That's her. She's making her own adult choices. We shall see what the courts say. I'm reading your comment. I just don't want to highlight it. It's me, Bedazzle, because I didn't go over there, and I don't want to be posting what she did, and she did it behind a wall. So I ain't trying to put too much up there. That's not kind of out there. Preponderance is on 51%, not a lot, right? I hear Judge Million say that all the time. I don't know, Irene. I don't know. Hey, Rhonda F. I don't know. Ooh, like y'all said, just child. That's really all I got. Even if he doesn't win, he's gonna break. Oh, just the court costs. It could, yeah. Ooh. Hold on. Let me not highlight that. Tasha K says she takes people. So I'm quite sure Kevin's people got that mess recorded. Like you can see who's calling. That's just what I think, but you're right. I love your channel. Okay, well, I had to pre-read it. Okay, Esty, I got you. Yeah, they probably do, and not just caller ID. I feel like there's more than that you can trace. So I just want to. I don't know how much they'll present, but I'm so curious about what they'll say and how they connected and can prove it's connected directly back to her for sure. Her husband must be tired of her mess. Oh, Francois. Oh. He did, Dre. He sued for defamation. Let me take it back to the top. It's up there. Yep. It got 5 causes of action. Defamation is number 5. He did. It's in there. Hey, Lori. Woo, y'all. So that'll be another one I gotta add to the list to track to see what happens. Let me make myself a note. We'll see. We'll follow it. Okay. All right, y'all. So that's all I have. I will see y'all in the YouTube streets. See you tomorrow for Lunch Break Live. And yeah, I'll talk to y'all later. Bye.
I've been taking my time, I've been taking my time. Taking all of your time, taking all of your time. I've been taking my time, I've been taking my time. Taking all of your time, taking all of your time. We've been talking about it for a while. Before we take a chance and do this, before we looking back as foolish. Talk about it for a while. Before we take a chance and do this, before we looking back as foolish. We got me floating, and I can take it. You got me floating, and I can't take it. You got me floating, and I can take it. You got me floating. Floating, and I can't take it.